North Carolina does not have a specific statute requiring landlords to give a set number of hours notice before entering a rental unit, but that doesn't mean North Carolina landlords can enter freely. The standard of reasonableness still applies. Welcome to tenantscreeningbackgroundcheck.com. Here's what North Carolina landlords need to know about property entry. In North Carolina, reasonable notice is the legal standard for landlord entry. While no specific number of hours is mandated by state law, 24 hours is the generally accepted benchmark for reasonable notice, and courts would look to this standard in any dispute. Your lease agreement is particularly important in North Carolina. If it specifies entry procedures or a notice period, those terms are binding on both parties. A well-drafted lease that addresses entry is your best protection as a landlord. North Carolina permits landlord entry for repairs, maintenance, inspections, showing the property to prospective tenants or buyers, and in emergencies. Emergency entry without notice is permitted when there is an immediate and serious threat to the property or tenant safety. North Carolina tenants have the right to quiet enjoyment. Entering without notice, or repeatedly entering for no legitimate reason, can constitute a breach of the lease and give the tenant grounds for legal action. North Carolina landlords should also be aware that while state law is limited on entry specifics, some municipalities may have local ordinances that impose additional requirements. Check your local jurisdiction's regulations. For North Carolina landlords, put clear entry provisions in your lease, give at least 24 hours notice as standard practice, enter during reasonable hours, and keep documentation of your notices. For complete landlord resources and tenant screening tools, visit tenantscreeningbackgroundcheck.com.